Order. Welcome to meeting number 65 of the House of Commons Standing Committee on Citizenship and Immigration. Today, we will be dealing on the potential matter of privilege regarding Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. We are joined by Mr. Randall Emery, Executive Director, Canadian Citizens' Rights Council. Welcome. Thank you for appearing before the committee. Mr. Emery, you will have 5 minutes for your opening remarks, and then we will go into a round of questioning. You can please begin.
Thank you, Madam Chair. I accepted the committee's invitation to come today because it's important to set the record straight. I've heard committee members say that the issue is privilege. With the greatest of respect, I say the issue is the role of stakeholder and consultation in a democracy. Consultation with stakeholders is not just permitted, not just something that's tolerated. Stakeholder engagement is vital and necessary in a democracy. Stakeholder engagement means that decision-making gets to benefit from the widest possible range of perspectives and points of view. Stakeholder consultation exposes the implications and the effects of legislative proposals. Stakeholder engagement empowers Canadians. It gives voice to people and communities that might not otherwise be heard. Politicians might not always like what stakeholders have to say. You won't always appreciate the feedback. But hearing from Canadians is the price of holding public office in a free and democratic society. It's not just about listening to stakeholders. Engagement and dialogue run two ways. True dialogue means more than passively listening. It means talking to stakeholders, reaching out, bouncing ideas, exploring options, sharing alternatives, seeking input, gathering feedback. I challenge the very notion that in 2023, it is still appropriate to make laws in secret, to develop amendments behind closed doors, to purport to do the people's work without the people seeing or hearing or knowing. Quote, government must be open by default, end quote. Who wrote that? Justin Trudeau. Quote, secrecy, censorship, control, putting us in step with countries like China and North Korea, end quote. Who wrote that? Pierre Poilievre. We want to see a more transparency. We want to see people able to trust their institutions because they see the decisions being made in a transparent manner. Who said that? Jagmeet Singh. I urge the committee to remember that openness and transparency are vital to our democracy. What you want to call privilege is in fact the triumph of secrecy and opacity. This isn't about democracy. It's about protecting a closed system that shuts Canadians out. This committee wants to hunt for the MP who allegedly consulted with stakeholders. This committee has interrupted its ordinary business to find out whether an MP did too much stakeholder engagement. Too much stakeholder engagement? Too much dialogue with the people affected by lawmaking? This isn't Belarus. This isn't Bahrain. This is a democracy. This is Canada. It's not a crime for MPs to dialogue with Canadians. Suppose an MP consulted with stakeholders. What's wrong with that? Suppose an MP tried to gather feedback on amendments to the bill. Does that not strengthen democracy? Suppose an MP tried to gather feedback on amendments. Suppose an MP said, instead of taking marching orders from the kids in the PMO or the minister's office or the OLO before voting, I want to hear what stakeholders have to say. How is that a breach of privilege? Is that not the very essence of how honorable members are supposed to act? Consulting with stakeholders, talking to stakeholders, sharing, listening should be routine. Those should be the ordinary functions. But after today, MPs will think twice before sharing with stakeholders. Today is going to have a chilling effect on stakeholder dialogue by members, and that's a shame. To be clear, I did not receive numbered amendments from a member of Parliament or from a staff member. I did not. But if one of your committee members was behind this consultation with stakeholders, then I say bravo. To that unnamed MP, I say thank you for challenging secret lawmaking. Thank you for upholding democracy. Thank you for respecting, not disrespecting, Canadians.
Thank you. Before we get into round of questioning, just we want to read some important information so that all members are aware what we can do and what we cannot do. Before we begin, I wish to make an important statement regarding today's meeting. Pursuant to Standing Order 1082 and the motion adopted on Monday, May 8th, we will be studying the potential matter of privilege originally raised on Wednesday, May 3rd, and hearing from a witness, drawing on procedure, practice, and precedent. I wish to make the following very clear to all the members. The committee cannot decide whether this matter is a prima facie question of privilege. Only the Speaker has this authority once a matter is raised in the House. This is why we are referring to this as a potential matter of privilege. The committee cannot censor or punish the conduct of a member or another person. Only House has its power. The committee should not attempt to investigate the matter on the assumption that the matter is prima facie question of privilege, because such a determination, which rests with the Speaker, has not been made. As I already explained in my ruling on Monday, May 8th, the committee's authority is limited to reporting a potential matter of privilege to the House, as explained on page 1060 of the House of Commons Procedure and Practice, 3rd edition. Such a report should describe the situation, summarize the facts, provide names of peoples involved, if possible, state that there may be a breach of privilege, and ask the House to take measures it deems appropriate. Today, the committee is hearing from the witness as a way of better understanding the facts related to this matter. I would then encourage the committee, if it indeed wishes for the matter to continue its course, to report the matter to the House as soon as possible. As we have heard in many speakers' rulings, including as recently as this week, questions of privilege should be brought to the Speaker's attention in the shortest possible delay. In order to do this, the committee must first report the matter to the House. Thank you all for your attention. With that, we will go into round of questioning, and we will begin our 6-minute round with Mr. Kimmich. Mr. Kimmich, you can please begin.
Thank you, Chair. Sorry for missing Monday. It was unavoidable on my part. I had a personal matter to attend to, and my daughter broke her finger too, so it's a bonus prize. I can't provide the evidence if you'd like the X-ray pictures too. Mr. Emery, thank you for coming before the committee. Quick question to you. How did you know the amendment numbers?
I received that information.
From whom did you receive the information?
I'd like to just reiterate that this is about protecting a closed system that shuts Canadians out. The answer to your question is that I received it from another stakeholder.
From another stakeholder?
Yes.
Which stakeholder was this?
Michel Vallée.
Michel Vallée. Is he with a particular organization, or is he with just a member of the public in general?
Just a member of the public.
Okay. And when Mr. Vallée communicated these enumeration of the amendments, did he provide it as a document, or did he refer to it in an email?
As a document.
And so you will receive these electronically?
Yes.
Do you still have that email, including the electronic document, in your Gmail or whatever email you use for work?
I do not have an email.
Did you delete it?
No, I did not receive it over email.
He just handed you a paper copy at some point?
No.
So it was over a phone call?
No.
So how did he communicate these to you?
A message.
A message over electronic means like WeChat, WhatsApp,
Yes.
Signal? Okay. And when was that communication?
On April 20th.
And did he mention whom did he receive this information from?
Again, I'd like to say that stakeholder engagement is not just something that is permitted, not just something that is tolerated. It is vital and necessary in a democracy. What she indicated is that it came from a member of the bloc.
You're saying Michel Vallée said that he received this document from a member of the bloc?
From the bloc.
A member of the bloc.
That's all the information I
Okay.
have.
You probably saw that in my when I raised the matter of point of privilege. I don't blame you, Mr. Emery. This is entirely not of your doing. It wasn't even my motion to bring you before this committee, and I wasn't here at that meeting either when this motion was passed. The reason we have all these rules is so that the work can be done to the committee. I would like you then to be, if you can, tell me this. When it was communicated to you, what was the context of the communication? Was this one stakeholder group sharing it with another, and he had just obtained the information in a roundabout way? Or was he communicating them to you so that you could do your work more easily?
This was in the context of a conversation.
Okay, and so and you didn't ask for this information? He just volunteered it over to you?
I did ask for this information.
Did you know that he had this information? Or did you come to be aware of it during the conversation with him?
I knew, yes.
Okay. And then later on, like in that email that has been shared with the committee, there's a line in there that you say, what you've heard about the Liberal NDP compromise is that they will offer sub-amendments to the NDP amendments to increase the connection test to 1095, only for parents, and by right versus grant. Did you find out that information from Michel Vallée as well, or did you find out through your communication with MP offices and MP office staff?
Would the member mind repeating the full question?
Yeah, sure. So I hope that time is not deducted from my overall. So you wrote in your email, what I have heard about the Liberal NDP compromise is that they will offer sub-amendments to the NDP amendments to increase the connection test to 1095 days, 1,095 days, comma, only for parents, comma, and by right versus grant, point.
And the question is, did I receive...
Did you come to understand that this is what was going to happen to one of the NDP amendments through Michel Vallée, or did you come to understand that this is what was going to happen based on communication with different MP offices and their staff?
I came to understand that, as Ms. Kwan had mentioned in the last meeting, that she'd shared this very broadly.
And when was this meeting?
This meeting?
The meeting with the NDP member.
This was just, I don't remember.
You don't remember? Do you want to take a moment maybe to look through your calendar for when did this happen?
No, I don't recall.
Okay, and during this meeting, this information was shared that there were going to be 3 sub-amendments. Did you get it at any point in writing that there would be a series of sub-amendments to NDP amendment?
I'd like to stop right there. Again, this is I did not have knowledge of 3 sub-amendments.
Then how is it possible that you could have written that they will offer sub-amendments to the NDP amendments to increase the connection test to 1,095 days, comma, only for parents, comma, and by right versus grant? Those are 3 distinct ideas that were then done at this committee to one of the NDP amendments. It was, debated. There was the officials had come here to inform the committee on what the impact would be of each amendment. That's when I raised the point of privilege, because I understand that sometimes stakeholders discuss things and they may come to understanding, but you had the numbers, which we now understand that come from Michel Vallée, and then you basically described what would happen at committee, and in your description it was just, your sense of divination is expert, that you're able to guesswork. So I'm just wondering, with this meeting with the NDP, did they communicate them to you in writing? Were they very specific on what they had been told by other members on what would happen?
Sorry for interrupting, Mr. Kimmich. Your time is up. I gave you extra few seconds in the time which you had to repeat your question. We will now proceed to Mr. Dhaliwal. Mr. Dhaliwal, you will have 6 minutes. You can please begin.
Thank you, Madam Chair. Madam Chair, first of all, I would like to thank Mr. Emery for joining us here today, especially on a short notice. On behalf of my colleagues on this side, I want to thank you, Mr. Emery. But on the other hand, we want to make sure that you tell the committee the whole story, because you are a very key witness to this, and I hopefully you will be able to answer the question that myself and other colleagues on both sides have. In your email that you sent on April the 28th to staff in the office of Mr. Kimmich, you specially referenced sets of amendments to Bill S245 related to after first generation exceptions in the Citizenship Act NDP 1, NDP 3, NDP 5, NDP 8, NDP 12, G2, G6, G8, and G9. How did you come to know about the specific content of the amendments that you had listed in your email to Mr. Kimmich's office? Further, how did you come to learn which numbers had been attributed to this content?
As I've just indicated.
No, but you said, can you repeat it?
I'm sorry?
You said that you had a meeting with Madam Kwan. Is that correct?
No, I'm sorry.
Michelle?
No. Please let me be clear. Okay, as I said, no member of this committee shared amendments with numbers with me.
So
Numbered amendments.
You got a message from Michelle Bellet.
Yes.
Is that correct?
That's correct.
And how do you know, how do you trust that member, Michelle Bellet was telling you the truth that this came from the block?
That's just what was said. This is, I don't know that. I can't say what's true, what's not. That's just what I was told.
So the information that you think that you put in your letter is not the first-hand information that you had to particularly say what it is.
Are you referencing the numbers?
Yes.
The numbers were in a document.
In the correspondence you sent it to Mr. Kimmich's office on April the 28th, you referenced that there is no question in my mind that the Liberals will amend this bill. There are both external and internal reasons. Could you please speak about what you meant by the language and what external and internal factors were you alluding to?
Well, that was an assertion on my part. And by internal reasons, very simply, I know that there were members of the Liberal Party who've been on record publicly who support this. Those are the internal reasons. The external reasons is that there are folks who have been talking to members of the Liberal Party. And I believed when I wrote that I felt confident that the Liberal Party would amend this for those reasons.
No, but you said that folks that talk to the Liberal Party.
Yeah.
Can you tell me who those folks are?
Well, I was one.
So who did you talk to on the Liberal side? Can you tell me?
Sure, I spoke with Vanessa Cranston.
Which day did you talk?
I don't remember.
Did she tell you all these amendments by the number? That's what we're...
No.
And you also mentioned a meeting, Madam Kwan. Is it the meeting that you're talking about, meeting that happened in the committee meeting or a meeting beside the committee meetings?
As I said, I don't recall exactly when.
No, but I'm not asking you when. All I'm asking you is the meeting that you're referring to is the committee meeting or a meeting outside this committee room?
I don't recall. I mean, I don't think it was in this committee meeting, but you know, it was verbal. It wasn't in writing.
So, like, if you can't even recall, it's amazing that you can, you know, point a finger on Block, and then you point a finger on Madam Kwan, and how can we trust you? And, you know, the information that you're giving to committee is true.
I am here to answer truthfully. I'm answering truthfully.
So I'm going to give you another chance then. If you can give a think process. You know, you are saying that you do not even remember when you talked to Madam Kwan, whether it was in the committee room or outside. How many times have you talked to Madam Kwan outside the committee room?
Perhaps about maybe 4 times.
And on any of those instances, did she bring in and told you exactly these amendments, how the Liberal or the government and the NDP amendments that you referenced in the letter?
As I understood her testimony from the last meeting, or her statements from the last meeting, she had said that she shared a general strategy with myself and other stakeholders.
So it's okay to share general strategy. But
Sorry for interrupting,
general
Mr.
strategy, yeah.
Mr. Dhaliwal, your time is up. We will now proceed to Mr. Brunel Desep. Mr. Brunel Desep, you will have 6 minutes. You can please begin.
Thank you very much, Chair. This is not exactly the committee meeting I was expecting. I prepared myself, Mr. Emery. I thought he was going to enlighten us as to what happened. And I get the impression here I didn't know what was going to happen. We've never had a discussion, have we, Mr. Emery, I believe? You came as a witnesses. I was even being replaced at the time. Is that correct? What happens all the time? Okay, we're going to check for the signal coming through. The interpreter is at work. Yes, good afternoon. This is not the committee meeting I was expecting. I was expecting to be enlightened a bit on what happened, and the information seems to be quite surprising. We've never met, have we? Even when you came to testify here, I was being replaced, and I was at another committee.
The question was that we'd never met.
Oui.
And the answer to that is yes, we had never met.
OK. On n'a jamais eu de communication.
Okay, and we've never communicated by text or email or anything like that.
Bon, ça part bien. Vous avez parlé de...
You mentioned a person, Michel Vallée, and you spoke of the Liberal Party, Miss Vanessa Christian, I believe, Jenny Kwan, you spoke with her. I believe you that you are here to testify and tell the truth. But when I arrived here in the committee, I am the individual who said, I haven't received the sub-amendments from the NDP, and I have the impression that people perhaps discussed it without my being involved in that conversation. And perhaps it is the Bloc that gave it to a stakeholder. But what I don't understand in that story
Translation cut out. What I don't understand in that...
régler ça parce que c'est trop important, là.
you know,
Mr. Brunel Desep, can you just say a few sentences? Let's see if we can...
C'est quand même un petit peu important. Fait que...
well, it's very important, so I want to make sure that it's working correctly, all right? Is the translation, the interpretation working or not? Well, if we have a technical problem with the signal, if it's cutting in and out, thank you. We'll check it.
Yeah. Is his this thing in properly? Because sometimes 2 minutes so that the clerk can have a look like what's the problem. If seats, Mr. Brunel Duceppe. Let's wait for Mr. Brunel Duceppe. I think he just might have gone. So that Mr. Brunel Duceppe is back. Start from the beginning because if there were some issues of the translation.
On recommence.
Okay, let's try again. Take it from the top. We've already clarified that we have never met, and the only real question I have, Mr. Emery, I know you're here to speak the truth. I have no doubt about that. You look somebody who's quite truthful, and this is the first time we are talking together. When the Conservatives came out, this was a notorious email that you authored, that you had certain information. Just before that was made known to us, and I was in the committee, and the Liberals were tabling various sub-amendments. I said, I haven't seen these sub-amendments. It's quite a complex issue here. Could we not have copies of those sub-amendments for all members of the committee so that we can prepare ourselves to discuss this? So what I don't understand in all of this is that the bloc somehow is linked into this somehow. But I was not at all aware of the Liberal sub-amendments that were maybe prepared in response to NDP sub-amendments. From the very onset of this affair, I said, I have nothing to do with this. I'll just let it go, see what happens, stand back. So you can understand why I'm surprised to hear you say that the origin of this stuff is from the Bloc Québécois. Can you enlighten us on that, please?
That is what I heard, and I understand that this is not a court of law where hearsay
No.
is.
Non, on veut juste...
I'm just speaking truthfully. That's the information I have.
Ce que vous avez entendu, c'est que c'est le Bloc...
So what you heard was that the Bloc Québécois had shared some of these Liberal sub-amendments. Is that correct?
Ah, OK.
Sub-amendments?
Donc, pas les sous-amendements.
Not the sub-amendments, but in this email that the Conservatives are alluding to, the mention was made of Liberal sub-amendments.
OK. Je ne suis pas certain de comprendre. Donc, dans le courriel...
Okay, in the email that was received by the Conservatives, it mentions Liberal sub-amendments are mentioned in that email. But it's not the Bloc that gave you those sub-amendments, to the Liberal sub-amendments. So the question we're all asking ourselves is, how were you aware of these Liberal sub-amendments? And I don't see why the Bloc is being mentioned in all of this. That's my concern and my question.
Je suis désolé, c'est la surprise que j'ai. Là, donc...
I'm just surprised. I'm caught off guard, if you will. I'm just...
Just to be clear.
Okay.
I did not receive any amendments nor sub-amendments language from any member or staff. Okay? I received general information on strategy. What I communicated in my email reflected an anticipation of the execution of that strategy with regards to sub-amendments. And with regard to specific numbers, that I did receive.
OK. Mais les libéraux...
Very well. But the Liberals obviously did not share the sub-amendments that they were going to present, because I was the first to be surprised when they did table these sub-amendments. And I'll repeat it once again. The Bloc could not have shared Liberal sub-amendments. That means that the Liberals have provided us with them, which is impossible. I never received them. So this is what I can't understand, how you managed to get that.
I'm sorry.
Ce que je comprends pas, c'est que comme...
What I don't understand is how the Bloc could have shared the Liberal sub-amendments when the Liberals did not share those sub-amendments with the Bloc.
I saw no sub-amendment language.
OK. C'est juste par rapport aux amendements.
Okay, just the amendments then, the NDP amendments. And those were coming from Bloc Québécois source?
With numbers.
Qui serait venu de...
From another stakeholder, correct.
OK, parfait. Écoutez...
Okay, fine. Madam Chair, I'm going to have to check things out here. I'm questioning myself about my own intervention here. I'm learning this right now, live, and I think I will have to check, perhaps with my team. Mr. Emery spoke with a lot of individuals, apparently. He spoke with the Liberals and the NDP. Can we explain...
Yes, Mr. Dhaliwal has a point of order. Mr. Dhaliwal.
Madam Chair, it is quite reasonable that Mr. Brunel Desap do want to discuss with the other staff, and I think we should suspend the meeting for a few minutes if he wants to, and I would really love to see if that is his intent.
We have 30 seconds left, so I would ask Mr. Brunel Desap to complete
Non, je vais laisser mon
his
temps aux
time,
autres.
and
J'ai fini,
we will
Madame la
then proceed
Présidente.
to the next.
No, Madam Chair, I'll cede the floor, and I'll leave the floor to others. My time, whatever time is left, can go to someone else.
Okay. Thank you. We will now proceed to Ms. Kwan. Ms. Kwan, you will have 6 minutes.
Thank you very much, Madam Chair, and thank you to the witness for being at this committee meeting today. First off, I'd like to touch on the issue around the overall strategy because that seems to be the central issue here right from the beginning. And I'll repeat again at this committee that I engaged with stakeholders all the way through to talk about S245 and what amendments needed to be done. And through that consultation, it was clear to me that the groups wanted the Lost Canadian issues addressed once and for all, and not just related to the narrow category that was established under the bill itself. And there were a variety of areas to which we needed to address, including those who had lost their right with the right to pass on their citizenship to children born abroad. There were issues around what I loosely call as war heroes. Those are individuals who fought for Canada, went to war for Canada, for example, died for Canada and never came back. However, at the time when they did that, because Canada was not formulated as a country, Confederation has not taken place, they then therefore were not recognized as citizen in that technical sense. And so part of the goal, of course, was to try and address those people and to make them whole, even though they may have passed on, because their subsequent descendants have already had access to Canadian citizenship. And it's just really a symbolic thing. The other thing that, another category that needed to be addressed, for example, included those who faced discrimination because of Canada's immigration laws and citizenship laws over the years, and was trying to sort of capture those individuals and make them whole. Anyway, there are a number of these kinds of categories, and right from the get-go, that was what I had made it clear that that's what I was trying to do. And in that process, it was determined through the stakeholder consultation that they would like to see the government address this by way of conferring those rights back to them. And so in that process, I came up with a number of suggestions to address that. So addressing, for example, establishing a connections test by way of being in Canada for 1,095 days, consistent with what the Citizenship Act outlines by way of the number of days. As an example, was one connections test. There were other connections tests that I thought was important to establish connection to Canada, such as if someone voted for Canada or is on the voting registry, or, for example, someone who went to school here or who worked for Canada or represented Canada abroad. So those were the categories for sure that I thought, we should consider to establish that connection. And so in that process, in discussing all of this with the stakeholder groups, I proposed that's what we should do by way of the amendments. So various drafts and instructions went into the law clerk, who then came back with lots of different drafts and different things at different times. But in that process, what I also recognize is this, that I needed the government to support this. I had these conversations, by the way, with the minister and minister's office to see if we can come to an agreement and work collaboratively to find a way to address the Lost Canadian issue. And it was a long process, and we put a lot of work into it. And while I didn't get everything I wanted in those negotiations, but that said, it was generally agreed to that we would address the issue of the Lost Canadians on this second generation born abroad question by this establishing of a citizenship test. And then for that test, the people to apply that test to, I had wanted it to apply to parents and grandparents. The government only wanted to apply to just parents. I don't agree with it, but I also recognize that I'm not the government, and this required negotiations, and that's sort of where it landed. So that overall strategy of where we landed was something that I did share with stakeholders all the way through from the beginning. And this committee was advised of that as well. So there's no mystery there. And in terms of specifically on the sub-amendments, yes, the sub-amendments, I should just point out too, those sub-amendments that members are referring to was never submitted to the clerk, by the way. as an official package that came back to us. It didn't until when we're debating this matter. But loosely, what were the sub-amendments to do that I knew that the government would amend my amendments is that they would only apply the 1095 connections test to parents. I knew that right from the beginning, going in, even before, before all of this stuff went into the clerk. So in my view, which is what I have been saying all along, that I do not believe that there was a breach in confidence here, most certainly not by me or my staff. We did not provide the amendments package from the clerk after it was released back to us, to anyone. And we had drafts with the Ledge Council on the amendments that I wanted to achieve, and we did share some of those drafts with stakeholder groups to invite their feedback and so on and so forth. And that's all within the purview of what we are allowed to do and as part of the normal engagement with stakeholders.
Sorry for interrupting, Ms. Kwan. Your time is up. You'll get an opportunity when we come next. We will now proceed to Mr. Kimmich for 5 minutes. Mr. Kimmich, you can please begin.
Thank you, Madam Chair. Mr. Emery, just to go back to, you said you got the amendments April 20th from Michel Vallée. And how were they provided to you again? On paper?
Electronically, message.
An electronic message. Through what medium again?
A messaging app.
Which messaging app?
WhatsApp.
WhatsApp. And you don't have that original message anymore?
I do.
You do? Would you be able to share it with the committee?
If, I suppose.
Yes or no?
Yes.
Yes. Madam Chair, can we take that as he will share it with the committee to make sure there's follow-up? Thank you, Madam Chair. So I'm going to ask you, do you believe Michel Vallée? When they tell you that they obtained it from a block staffer or from the block somehow?
I do not have I didn't question it.
You didn't question it? So on face value, you think this person is trustworthy? They were telling you the truth, that's where they sourced it from?
We're getting into areas here that this is just something I heard. I'm answering truthfully. That's all I can say, I think. I'm not going to speculate on more.
I've never met this person, and we have met before over Zoom way back in November. So I have nothing else to go on. I don't know who this person is. They did send a letter to the chair of the committee on the 15th of March, 2023, and that's the only communications I've seen from this particular person. So I'm just asking for your character assessment. Like, do you think this person is being accurate when they say they specifically got it from someone in the block and that they're not either accidentally misleading you or just made a general statement that it was like a block supporter who had this? I'm trying to determine how widely was this document shared.
That is, I think, not a question I'm able to answer.
Okay. This document that you got digitally through WhatsApp, did it have any annotations on it? Were there any, handwritten annotations or highlights
No.
that were on it? It was a pristine document and had the enumeration of all the amendments on it. Did it have the date of when those amendments were distributed to the committee?
No.
Okay. And to the best of your knowledge, when discussing this with other stakeholder groups and other people, nobody else said that they had these amendments?
That's correct.
That's correct. Didn't you think at any point that you should have informed the committee that you had obtained this package document with digitally of the amendments being considered? To inform the chair or any one of us on the committee?
What I think is that I have acted in a way that has not violated any obligations on my part. The issue here is really about stakeholder consultation in a democracy.
So sorry to interrupt you, but at no point did you think you should inform the committee that someone had shared with you this document? It's just a yes or no. Or you're unsure, that's okay too.
This is not something that came into my mind.
No. Have you ever worked on Parliament Hill or for a member of Parliament?
I volunteered briefly.
briefly? For whom?
For Ms. Kwan.
Ms. Kwan. Okay, so you're familiar with the work that is supposed to be going on here, and that that particular document shouldn't be shared with others, no? Or did you ever do committee work for Ms. Kwan?
Most of the work I did was answering constituent emails, drafting responses to constituents.
So you have worked on Parliament Hill. As a volunteer, you have had an interaction. Okay. Madam Chair, I'm prepared to move the motion on breach of privilege. There's other people involved here. This goes far beyond. I think I've heard enough. And so I would like to move. This is the first opportunity that I have, based on the information I've received, to move the motion for the potential breach of privilege, which is that the committee report to the House of Commons the potential breach of privilege resulting from the premature distribution of notices of amendments to Bill S-245, an act to amend the Citizenship Act granting citizenship to certain Canadians, to a member of the public before clause-by-clause consideration and amendments and sub-amendments were moved at committee.
Thank you. Just point of order.
Madam Chair, it's quite extensive what Mr. Comich is bringing forward. I would like to take a suspension so we can have a discussion.
Yeah, so that is fine. So have you given this to the clerk? Just, okay. So we will get that to all the members. I will suspend the meeting for a few minutes so that members can have a look at the motion, and then we will reconvene. Thank you. The meeting is suspended. members who are virtual to please on their cameras. Okay, thank you. We have a motion which has been moved by Mr. Kimmich on the floor. I hope everyone has received the copy of that motion in both official languages. Okay, so now we are with that motion, and we will have Ms. Lalonde speak. Ms. Lalonde. And then Mr. Kimmich.
Thank you very much, Madam Chair. And, I think I want to say thank you to the witness who came to speak with us. I really appreciate his candor and his transparency. I'm hearing a lot of hearsay, and for that reason, I move to adjourn the debate.
Motion has been moved by Ms. Lalonde to adjourn the debate. It's a non-debatable motion, so we will have to go into a vote on that. So can I please ask the clerk to take the vote?
Mr. Ali.
Support.
Mr. Dhaliwal.
Support.
Mr. El Khoury.
Pour.
Madame Kayabaga.
Pour.
Madame Lalonde.
Pour.
Mr. Kimmich.
Against.
Mr. McGuire.
Against.
Mr. Cram.
Against.
Mr. Baldinelli.
Against.
Mr. Brunel Duceppe. Ms. Kwan.
For.
Yeas 7, nays 4.
So the debate is adjourned. We will now go back. Ms. Kwan, you have a hand raised.
Yes, I was just going to ask you if we're going to go back to the amendments clause by clause for S245, and if yes, I would like to move on to the.
We will be going back to the witness. That's where we left. So we will complete that round. So we were with Mr. Kimmich. Mr. Kimmich, you have a minute. Yes.
Thank you kindly, Madam Chair. So the cover-up begins, I guess. I find it appalling that we would not at least debate a potential breach of privilege of a member, because it impacts all of us, impacts the whole committee. And we could at least report this to the Speaker, and the Speaker can make a decision so that we can continue on with other things here. And let the Speaker decide this, and if he directs it to Proc, then Proc can decide and then investigate and call this Michel Vallée and other people to do it too. And so I just find it appalling that this would be done. Like, I have been, I think, infinitely reasonable. I have not tried to prolong things when I have been here. And I've, everybody knows my position. I've been very clear. I have hid nothing from nobody. When I found this and this was sent to me, I thought the entire committee needed to know. I can be very reasonable. I can also be very unreasonable, as I have done other committees. And I find it appalling that we would not at least debate it and have a vote today so this could be sent to the Speaker, and the Speaker can make a decision. And based on everything that he saw here, he can then make a determination if there was a prima facie breach of privilege. So again, I'm just appalled that we would do this and adjourn debate on my motion.
Sorry for interrupting. Time is up.
That's okay, Chair. Thank you.
We will now proceed to Ms. Lalonde for 5 minutes.
Thank you, Madam Chair. I do have some questions, and again, I want to reiterate, Mr. Emery, thank you for coming in front of our committee and speaking with us. I do have a few minutes only, so I'm going to have a brief answer, if I may ask. Mr. Emery, you spoke to someone who received numbers, by which we mean NDP 1, NDP 4, G5, etc., and I think you've alluded to that. That documents you're referring to as is the amendment package. You believe this document came to Michel Vallée via the block. In your email to Mr. MP Kimiek, when you refer to sub-amendments, you only have strategy information, not specific wording and no numbers. Is that correct?
That is correct.
Okay. You've also indicated you met with staff in the minister's office. Did those staff ever send you any documents? And to your knowledge, did they ever send documents to Michel Vallée?
There's two questions. So did they send any documents to me? No. And I have no knowledge of the other.
Thank you very much. When you met with minister's office staff, what was that? Was that a meeting you asked for, yes or no?
Yes, it was.
So at that meeting, I assume you advocated for change to Bill to S245 and other changes related to lost Canadians, correct?
Correct.
Did anyone in the minister's office ever give you a concrete yes or no, or tell you they definitely agreed with your proposal?
No, they did not.
Did they ever concretely tell you that they either agree or disagreed with any proposal from the NDP or any other party?
No, they did not.
Okay. Thank you very much for alluding. I know this is probably, we're on a few last minute, Madam Chair, I understand. Is there anything, Mr. Emery, that you would like to share to this committee?
No, thank you.
You have 2:21 you are at, so you have total 5 minutes, 2 minutes and 30 seconds.
Continue.
You know, I feel like this witness, in all fairness to him, did take the time on a very short time frame, came in front of this committee, did share some thoughts, and I have reason to believe that, you know, he comes with his transparency, as I mentioned, and his candor. And I think one of the fact that the witness and Mr. Emery did talk about, and that spoke to me, is the fact of always having consultation and broad consultation. I think not only we as Member of Parliament, but I know government have public consultation. I was just in Yukon, actually, Mr. Emery, a couple days ago, where we're doing consultation on immigration in Canada and how this should look forward. So this is always, in my view, very important conversation. I know that I'm, you know, a few minutes from ending again, Mr. Emery. I really want to say thank you. Thank you. I'm sure this was not easy for you to come in front of Parliament in this kind of ask. And we appreciate again the time that you made in your busy schedule and your commitment also to addressing immigration and certainly your passion for lost Canadians. Merci beaucoup.
Thank you, Ms. Lalonde. We will now proceed to Mr. Brunel Desaep for 2.5 minutes and then end this panel with Ms. Kwan for 2.5 minutes. So, Mr. Brunel Desaep.
Merci, Madame la Présidente.
Thanks.
I think as we start at 4:34 and that would end this meeting at 5:34 for this first hour. Has something changed?
So because we had some disruptions, just finishing this round with Ms. Kwan, and then we will end this panel.
Okay.
And then we will proceed with the second hour.
Okay.
Yeah. Mr. Brunel Desaep.
Well, I don't have much else to add. Generally, I understand that you've had communications, Mr. Emery, with various stakeholders, except the bloc, yourself directly. Well, there's going to have to be some verification done on that. It seems that several people from several political parties have been involved. I would like to thank you very much. As Marie-France has mentioned, thank you very much for your appearance here and to help us in the work of the committee. Now, as for S235. I wish you a safe travel home, and I won't waste any more of the committee's time.
Okay, thank you. We will now proceed to Ms. Kwan for 2.5 minutes, and we will then end this panel.
Well, thank you very much, Madam Chair. From my perspective, I think that it's important that we actually get back to doing the work before us, and that is on S245. The implication of lost Canadians is significant. There are many people whose lives has been disrupted, and they have waited for 14 years to see if changes to the law could be made. We have an opportunity before us today, and through Bill S245. And so it is my hope that we can focus in on the work before us, get the clause by clause done, refer the bill back to the House accordingly, and so that we can move forward. And I know that most importantly for the people whose lives has been impacted, they want to see this work done. And so, Madam Chair, so from my perspective, I just want to say thank you to the witness in shedding light on this. And I don't have any further question for the witness, and I do hope that we will be able to get back to doing this important work. Thank you so much, Madam Chair.
Thank you, Ms. Kwan. Thank you, Ms. Kwan. With that, this panel comes to an end. And on behalf of all the members of this committee, Mr. Emery, I would like to thank you for appearing before the committee, taking out the time on a very short notice. So with that, the meeting is suspended so that the witness can leave and we can have the witnesses for the clause by clause take their seats. Thank you, Mr. Emery, and the meeting is suspended. Let me just start the meeting, and then we'll come. We will start with clause-by-clause consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Today, we are joined by the witnesses from the Department of Citizenship Immigration. We are joined by Nicole Gerard, Director General Citizenship Policy, Yuan Huang, Senior Director, Legislation and Program Policy, Elaine Lorochelle, Senior Counsel, Legal Services Unit, Alison Bernard, Senior Policy Analyst, and Jody Dewan, Senior Analyst. Thanks a lot for your for appearing before the committee, and I really want to thank for coming again and again, and thank you for your patience and your understanding as we get through clause by clause on this. So we will get up, yes, Ms. Lalonde?
I just would like to bring an amendment once you're ready to start.
Okay, yeah, Ms. Kwan?
Sorry, I was just going to, get onto the order to move the amendments, but I guess you'll call members in the order that the package is showing for us to get onto the speakers list then, Madam Chair?
Yes,
Thank you.
we ended at NDP 3 as amended, and now G4. So, yes, Ms. Lalonde.
Merci beaucoup, Madame la Présidente.
Thank you very much, Chair. I'd like to propose that the bill in Article 1 be amended by removing 16 through 21, page 1.
These lines could be interpreted as shifting the application date of the first generation limit from April 17, 2009 to June 11, 2015. When actually Senator Martin appeared before this committee, she did acknowledge that this provision was something legislative drafters told her that should be included for clarity, but she did not really know the technical reason why. So we believe that the way this is written amounts to a drafting error. Pushing back the application date of the first generation limit would result in significant unintended consequences. Therefore, this amendment proposes to remove those lines of the bill. Merci, Madame la Présidente.
Mr. Kamich.
Thank you, Madam Chair. I move to resume debate on the potential breach of privilege motion.
The debate was adjourned on that, so...
Point of order.
Yes, Mr. Kamich.
I kind of know where you're going, Madam Chair, but that was a previous agenda item. Now we have a new agenda item, so what I'm proposing to do is to change the agenda item to resume debate on the potential breach of privilege motion. I had moved at the end of the previous section. So because it was a different agenda item that we were covering, I'm proposing to change the agenda item to resume debate on the potential breach of privilege motion that was before the committee earlier.
Okay, I'll have to suspend the meeting to consult the clerk and see what are the rules on that. So I'll suspend the meeting.
It's the same meeting. I want to be on record.
Meeting is
the same meeting right
is
now.
suspended. Meeting is suspended. If I can ask all the members who are virtual to please turn on their cameras. Who else is online? Mr. Ali, if you can turn your camera on. Mr. Daliwal. Okay, let's give a second. If he went to the washroom, let's give him a. Thank you. Mr. Kimmich has moved to resume the debate on the motion for which the debate was adjourned a few minutes ago. Based on the precedents and common practice, once the debate has been adjourned, when the debate is adjourned, a member who moves that the debate is now adjourned wishes to temporarily suspend debate underway on a motion or a study. If the motion is carried, debate on the motion or study ceases and the committee moves on to another business. Based on the precedents and common practice, the motion cannot be brought back in the same meeting, so I would rule that out of order. Mr. Kimmich.
Point of order. Just sort of get clarity for future meetings, because this might happen again. On page 1068 of O'Brien and Bosk in chapter 20, it says in the middle that the committee proceed, this is a motion that can be moved, that the committee proceed to, and in brackets, another order of business. We have another order of business here. This motion results in a matter then under consideration by the committee being replaced by the order of business proposed in the motion. If the motion is carried, the committee immediately proceeds to the order referred to in the motion, as footnotes in it, to what's happened at other committee meetings, including the Foreign Affairs and International Trade Committee from like way back in 2005. So I just want to be clear that how is that consistent with the ruling? Just so I have it. If you have a page number, Madam Chair, that I'm more than happy to look at it. But I was basically moving a motion to proceed to a different order of business to resume debate on the potential breach of privilege motion I had moved in a previous order of business. So I'm just to gain clarity for the future.
Sorry for interrupting, Mr. Kimmich. Once I have given a ruling, we cannot debate on that. So are you challenging my ruling?
No, I'm just trying to understand it so I cannot make the same mistake again.
So because it's not debatable, you can challenge my ruling if you want, but once I have given the ruling.
Madam Chair, you've been so reasonable so far. I don't have problems with you.
Okay, thanks for your cooperation. So we will resume back. Ms. Lalonde moved G4. So any debate on that, Mr. Kimmich?
So when Ms. Lalonde moved the motion, she mentioned that there could be, I think, legal consequences for the moving of the date. So can I just have the officials explain what those potential unforeseen consequences could be? Unintended consequences?
Madam Chair, as I mentioned in my initial remarks before this committee, the concern is that this amendment is pushing out the first generation limit to a later date.
Just pause for a second. I see a hand raised by Ms. Kwan. Yes, Ms. Kwan.
Oh, sorry, Madam Chair, just to get on the speaker's list to speak
Okay,
to this
okay,
amendment.
that's fine. Ms. Gerard.
Thank you, Madam Chair. So this amendment, as I was mentioning, is pushing out the start date for the first generation limit, which would have the impact of automatically conferring citizenship on untold thousands of individuals who are born abroad, and impacting persons who, since 2009, would not have been automatic citizens and would have had to have gone to get apply for and obtain a grant of citizenship. And so in automatically conferring citizenship to, untold thousands of such persons, the concern is that the twofold, that it's benefiting some through automatic citizenship, but not others in terms of all of those born after. And secondly, creating the potential for future lost Canadians in the sense that those who are receiving automatic citizenship by moving the first generation limit are impacted by being unable to pass on citizenship to their descendants and their future children and potential lost Canadians. Thank you, Madam Chair.
Yeah. Ms. Kwan, it's your turn.
Thank you very much, Madam Chair. Just very quickly to say, I do believe that this is a drafting error, that is going to be corrected with this amendment. So to that end, I'll support the amendment.
Thank you. Mr. Kimmich?
So it's been mentioned now that this was a drafting error, but this bill is exactly the same bill as S-230 that was considered by the Senate one parliament ago. And I've gone back through that committee testimony from officials, and nobody identified this as a drafting error at the time. And so I'm just wondering, when did the department discover that this would be a drafting error, and how did you discover it?
Ms. Gerard?
Madam Chair, in the preparation for these committee hearings, we conducted the usual sort of analyse approfondie, or the deeper analysis, if I can call it that in English. And at that time, we consulted among citizenship experts as well as with the Department of Justice. And this revealed a number of concerns with the drafting of the bill, which have been shared with this committee, and including the significant concern with this provision, which is impacting the first generation limit. And we did hear the sponsor of the bill indicating that this was not the intent, and my recollection of the sponsor indicating that given that that wasn't the intent, her support for the change moved by MP Lalonde. Thank you.
Thank you. Mr. Kimmich?
I'm just concerned here because S-230 was considered by a committee, and S-245 was redrafted, I assume, by the Senate clerks and the legislative clerks they have there. They were drafted in the same manner, and then it sailed through the Senate at all stages with the understanding that the work that had been done on S-230 on the previous committee, on June 16th, 2021, that this bill had no errors. At the time, I have two officials who spoke, Catherine Scott, Associate Assistant Deputy Minister, Strategic and Program Policy, Immigration, Refugee, Citizenship, Canada. In that testimony, that I've gone through it, didn't identify an issue here. And then Alec Atfield, the Director General, Citizenship Branch, Strategic and Program Policy, IRCC again, did not identify it as there being any known issue with the wording of the bill. But you said there were citizenship experts since then. Are these internal to the department or are they external to the department?
Madam Chair, I'm referring to the experts at this table before the committee this afternoon. Thank you.
Mr. Kamich?
So were you involved in the S230 drafting or the internal debate within IRCC when you learned that the bill was provided to the Senate? Because the two bills are identical. And at that point, did you raise concerns with S230, or did you raise them and they never got to the level where they were considered by more senior officials? Or was that work only caught later? Or are you, I don't have the exact people who were there at the time. Are you all new in these roles? It was a few years ago, so people do move around.
Yes, Madam Chair. So to respond to the question, no, I was not involved. We too have reviewed that testimony that the member is referring to. It's not my my understanding of that previous testimony is that officials were called to speak in general to Lost Canadian issues. They were not questioned with regard to any technical aspects of the bill. And so that may be why the member is noticing a difference. And I'm not aware that there was a previous deeper analysis of the technical drafting elements of that previous bill. What I can say is that in preparation for these hearings, the department, in consultation with the Department of Justice colleagues, conducted that analysis. And on our first appearance before the committee, outlined a number of key concerns with the drafting of the current bill. Thank you, Madam Chair.
Mr. Kamich?
In response, you had said there was potential. In a previous response, you had said there was a potential if we don't eliminate this section, that there would be future lost Canadians. So we would create another group of lost Canadians. And I've done this before on other sections. Can you give me an example of what you mean? Because it's a lot easier for us to work with examples. You're really good on the previous amendment, where actually I grasp the implications of what we're going to do once it was 3 times amended on the subclauses. So can you give an example of whom we're talking about when there are potential of future lost Canadians?
Ms. Girard?
Yes, thank you, Madam Chair. Since the first generation limit was put in place in 2009, those born abroad in the second generation to a Canadian parent, as this committee is aware, are not automatically Canadian citizens. And so a Canadian parent needs to sponsor their child for immigration to Canada, and then once the child becomes a permanent resident, they can obtain a grant of Canadian citizenship. With this drafting issue with the bill, the provision is moving the application of the first generation limit out to 2015, which means that those children born since 2009 who have been granted citizenship automatically become Canadians from birth, and so it's converting them from a grant of citizenship to a citizenship by right. When you obtain citizenship by right, you are impacted by the first generation cutoff and cannot pass on citizenship to your child, your future child born abroad. And so that is the impact of what this provision would do if it is not in the absence of the amendment, that's the sub-amendment that's being discussed. Thank you, Madam Chair.
Mr. Kamich?
So just so I understand this, so you're saying that if you receive citizenship by right, you are affected by the first generation. So I'm going to call it the FGL, it's just shorter. The FGL. If you get it by grant, though, you are not affected by the FGL on the FGL for 2009 or this new FGL that would be moved to 2015?
So that's
Gerard.
Yes, the member is correct. And so if you're receiving citizenship by right, if you're born abroad and you're the first generation, you cannot transmit citizenship automatically to your child born abroad. If you are granted citizenship, and typically the scenario is someone is naturalized in Canada and is granted citizenship, you are the same as someone who is born in Canada for the purposes of transmitting your citizenship to a child born abroad.
I had talked about that example. So I'm going to use myself as an example because I'm a naturalized citizen. So I'm not affected then, is my understanding? Because I'm...
Yes, Madam Chair. So that's correct.
Okay. And then, but if I had, so if my, let's say, I'll use my daughter as an example. If my daughter then left Canada post-secondary, studied abroad, had a child there, FGL rule applies to her child, and then that child, if they came back to Canada and applied for a grant of citizenship instead of, because they don't have it by right, that child would be affected? Like with this, if we don't eliminate this section, that's what will happen?
Ms. Gerard?
Madam Chair, I'm not clear on the location of the birth of the individual being described, and so the example is not clear to me. But the member is correct. If this provision is not removed, those children born abroad between 2009 and 2015 will become citizens automatically from birth, even if they were already granted citizenship, and they will no longer be able to transmit their citizenship automatically to their future children born abroad, creating lost Canadians in the future.
So I'll try to keep this to my last questions, but I feel like I could have another one. Because you said that they would automatically get citizenship by right, even if they were granted citizenship. And we've talked before that the department actually has very deep records of everybody's citizenship that's been obtained. I brought my citizenship card this week because I wanted to show it to my staff, you know, the old cards that were plastified. So I have that. There's like a number at the bottom. How does the department then treat that? Because you've granted it to some, but now some will have it by right. Would they be issued a separate number, or that is the number that you receive on your document of citizenship? Like, does that cause an administrative problem?
Ms. Gerard?
Yes. So the member is correct. We issue documentation, but we do not issue. The department doesn't issue the cards anymore. So we issue a certificate of citizenship, and then, you know, we have different application forms for different purposes, as the member knows. Whether someone's having to apply for a grant of citizenship, in terms of those children born abroad since 2009 who were affected by the first generation cutoff. Versus those who may be being born, you know, now or in the future in the first generation who are citizens by right, that would apply for a proof of citizenship because they are citizens automatically. It's just an issue of obtaining the evidence from the department, as I've described previously. Thank you.
I know some of my colleagues have questions too. The cards are better. I'm just going to say that. The cards are better than the document, the big certificate, because you can put it into your wallet. And frankly, I don't think I could prove I'm a citizen without that card. So, yeah. But thanks. Thank you for the explanation.
Thank you, Mr. Kivich. Now we will proceed to Mr. Cram.
Okay, thank you very much, Madam Chair. And to the benefit of those of us on the committee who are new, and that includes myself, I was wondering if you could offer an explanation as to the significance of the date of June 11th, 2015. Was that the last day that Parliament sat before the election, or was that the anniversary of some particular event, or why do you suppose the drafters would have chosen that particular date to insert into the bill? Thank you.
Ms. Gerard.
Thank you, Madam Chair. I believe that may coincide with the date of the last round of legislative remedies for lost Canadians, because there were two sets of recent remedies for lost Canadians through different amendments. One set in 2009, which remedied the majority of lost Canadians, as we've mentioned, and a subsequent set that were in 2015. Thank you.
Mr. Cram? Okay. Mr. Bedinelli?
Thank you, Madam Chair, and thank you for the witnesses for being here. And again, like Mr. Cram, I'm new to the committee, so I'm pleased to be here. I'm subbing in for my colleague, Michelle Rempel-Gardner. And as such, Madam Chair, I would like to move that we resume the debate on the motion that was tabled by my colleague on May 8th and have that debated. And that motion, if I could read it in, was should any relevant communications with Randall Emery exist wherein committee members or their staff distributed amendments to this individual, that those communications be tabled with the committee prior to Wednesday's meeting. That was tabled by my colleague at the last meeting, and it was provided in both English and French at that last meeting.
Thank you, Mr. Bertinelli. Just give me a second. Let me consult the check. So this is a thank you, Mr. Baldinelli. Mr. Baldinelli has moved a motion which is non-debatable, so we will go into vote. If I can ask the clerk to please take the vote. Thank you.
Mr. Ali.
Against?
Mr. Dhaliwal.
Against?
Mr. El Khoury. Madame Kayabaga.
Contre.
Madame Lalonde.
Contre.
Mr. Kimich.
For.
Mr. McGuire.
For.
Mr. Cram.
In favor.
Mr. Baldinelli.
Support.
Mr. Brunel Duceppe.
Contre.
Ms. Kwan.
Against.
Yeas 4, nays 7.
The motion is defeated. I have a hand raised by Ms. Kwan and then Mr. Kimich. Ms. Kwan.
Sorry, I don't have a hand up, Madam Chair.
Okay. Thank you. Mr. Kimich.
Sorry, just to return to this grant versus right of citizenship, because again, I'm going through, and the officials have said you've gone through the testimony on S230. I'm just wondering why it's taken like 2 years to get to the point where a problem was identified with the drafting. In it, Mr. Atfield, who was the Director General, there was a discussion, there were questions asked by Senator Atulajan on the grant of citizenship. In it, Mr. Atfield responds, it's worth noting that the discretionary grant of citizenship also then allows an individual's child to also pass on citizenship. The grant of citizenship allows that person to extend their citizenship so that basically the first generation limit will not apply to their child as a result. It resets the person's generational clock for passing on citizenship if that person has a child born abroad. So that was Mr. Atfield's understanding of S230, and now there's a problem with S230's drafting. Is this your understanding, like that this is the crux of the problem, that some people will be treated different because of the way that they have obtained citizenship? He talks here about a resetting of a person's generational clock. I'm not sure if this is the right terminology, but that's what's here for passing on citizenship if that person has a child born abroad. Because we've talked about the difference between right and grant, and that's the crux of the problem with this section. I seem to be understanding Mr. Atfield saying that, no, that's actually correct. That's the way that they want it to work here. Or if I'm misunderstanding it, then please correct me.
Ms. Gerard?
Madam Chair, from my hearing of the members' reading of the passage, my former colleague was seemed to be commenting to the effect that the discretionary grant under 5.4 is a grant, and therefore, like any other grant, as I've mentioned, those who are recipients of a grant are able to pass on citizenship to their children born abroad, as I've mentioned. But the member is correct that what I'm saying in summary is that by moving the date for the first generation limit, which we believe is undesirable because it would cause these unintended consequences of conferring automatic citizenship on untold thousands born abroad, who would then be unable to pass on citizenship to their future children born abroad, including those who have obtained a grant since 2009, because that was their main way to access citizenship being impacted by the first generation limit. Thank you.
How many people have received a grant of citizenship from the minister or a delegate since between 2009 and 2015?
Ms. Gerard?
Madam Chair, could I just clarify the question? Is the member referring to the discretionary grants, or is the member referring to grants in general? We will endeavor to obtain the statistics that are available for the committee, but I would just like to clarify the question. Thank you.
Mr. Committee, if you can please clarify.
This is why I'm glad we have the officials. If you could provide both numbers, that would be even better. If you could separate them out or make it clear if one number includes the other, that would be absolutely ideal. And I can give you maybe more specific dates. Like it would be the specific dates from when the first generation rule was introduced and I guess received royal assent in 2009 to when the Citizenship Act was changed in 2015 and royally assented to. That covered, I think, 600 lost Canadians in those changes. So between those two dates, not just calendar years, that would be ideal. Do you believe that it'd be possible to get that for the next meeting or before the next meeting?
Ms. Gerard?
Madam Chair, we will take that back and endeavor to provide statistics as soon as they can be made available, but I'm not able to say at this time how quickly we can turn that around, but we will do that as quickly as we can. Thank you.
Thank you. Mr. Kimmich?
I've had this one question wondering, when you get a grant of citizenship, are you obliged to do a citizenship ceremony, or is the oath just assumed that you have taken it? Like if there's a difference between them, like when a minister or his or her delegate gives through a grant citizenship, is there a ceremony that is obliged? You have to take the oath of citizenship, or does that bypass the requirement?
Gerard?
Madam Chair, typically an adult applying for citizenship is required to take the oath at a ceremony. So I just want to check with the member if that is answering the question, or if in fact he had a slightly different question.
I just meant because we're talking about grants versus the right. If you get a right of citizenship, you don't have to take the oath. You're a citizen by right.
That's correct.
But if you get a grant of citizenship where you've applied to the minister to obtain it, do you have to do a citizenship ceremony as well? Like, is the grant basically conditional on you going to take an oath in a citizenship ceremony? Some of you are nodding your head, so like anybody can answer this. I'm not picky.
Yes, Madam Chair. The final requirement, which an adult citizenship applicant is required to meet, is to take the oath of citizenship, and that is generally done at a citizenship ceremony. And that is the final step and requirement to be fulfilled before someone can be granted Canadian citizenship.
So then when you do provide the data on how many grants of citizenships there were, if there is a discrepancy between those who have been given a grant by the minister but have not gone through the citizenship ceremony, can that be, I'm sure it's going to be zero, but just in case it's not zero, if someone applied for a grant of citizenship and never actually went ahead and took an oath, then they would not be a citizen, then is my understanding. Even though they made a grant, it was approved by the minister, if you could separate out those numbers, it would just be an extra column, really. Is that possible?
Ms. Gerard?
Madam Chair, it's a requirement that the applicant has to fulfill, and generally is not going to become a citizen until the requirement is fulfilled. And so, the statistics we're able to provide, there wouldn't be any subdivision. The assumption would be that this is someone who's fulfilled the requirement, including taking an oath at a ceremony, and that's what the numbers we could provide to this committee would reflect. Thank you.
So you wouldn't be able to provide the total number of applications received by the minister for a grant of citizenship versus how many were actually granted the citizenship? Like, so
Ms. Girard?
Yes, Madam Chair, for a particular time frame, we could endeavor to provide this committee with applications received versus citizenship applications granted, which is ongoing, and there are ceremonies all of the time. Thank you.
Seeing no further debate on this, if I can ask the clerk to please take the vote on G4. 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 So we will be voting on G4. Mr. Clerk.
Mr. Ali.
In favor?
Mr. Dhaliwal. Mr. El Khoury. Madame Kayabaga.
Pour?
Madame Lalonde.
Pour.
Mr. Kimich.
Yes.
Mr. McGuire.
Yes.
Mr. Cram.
In favor.
Mr. Baldinelli.
Yes.
Mr. Brunel Duceppe.
Oui.
Ms. Kwan.
Pour.
Yeas 11, nays 0.
Coming to G5, Ms. Lalonde.
Merci, Madame la Présidente.
Thank you, Madam Chair. Well, I would like to move G5 and that Bill S-245 in Clause 1 be amended by adding, after line 18 on page 1, the following. 4. Section 3 of the Act is amended by adding the following after subsection 4.1, which was follows, colon. Exception. Transitional provision. 4.2, subsection 3, does not apply to a person who, on the coming into force of this subsection, was a citizen. However, subsection 3 applies to a person who, on that coming into force, would have been a citizen under paragraph 1b only by operation of paragraph 7n in respect of one of the parents. 5. Subsection 3 5.2 of the Act is repealed. 6th, Section 3 of the Act is amended by adding the following after subsection 6.3. Citizenship other than by way of grant, paragraph 1, G sub 1. 6.4. A person referred to in paragraph 1, G.1, who before coming into force of the subsection was granted citizenship under section 5 or 11 is deemed never to have been a citizen by way of grant. And 7, subsection 3, paras 7 of the Act is amended by striking out "and" at the end of the paragraph by adding "and" at the end of paragraph M by adding the following after paragraph. A person referred to in paragraph 1, G sub 1, is deemed to be a citizen under the paragraph from the time the person ceased to be a citizen.
My colleagues understand this because, as we said, this is a very complex piece of legislation. I want it to be clearly understood that all of the government's amendment only relate to the people we're calling the former Section 8. These are the folks that were born in the second generation abroad between 1977 and 1981, and are the people Senator Martin talked about and wanted to help with the original wording of the bill. These are the people who lost their citizenship when they turned 28 years old, either because they didn't apply to retain it or they applied and the application failed. We all agreed they should be scoped into this bill when we unanimously adopted Amendment G3. Further, anytime our amendments mention the letter number combination of G.1, that refers to those former Section 8 people who will now be citizens because of this bill. In several instances, these G1, former Section 8, have to be added into the current act to ensure they're treated the same as all other citizens who were born abroad and got their citizenship because it was passed down to them from a Canadian parents. So Amendment G5 proposes new text to clarify, and 1, the people whose citizenship is being restored by the bill, and that I mean the former Section 8, are being restored back to the date of their loss. And 2, that if since losing their citizenship at age 28, they received a grant of citizenship, they are now deemed to have never received that grant and are a citizen by operation of this bill. And 3, Madam Chair, that their child, if born abroad, would not automatically be a citizen. And the reason I say automatically is because earlier we adopted the NDP amendments that modified the first generation limits to say that the limitation doesn't apply if the child is born after 2009 and the parent has that substantial connection of physical presence in Canada for 3 years. Through this amendment, a former Section 8 person being restored by the bill who meets the substantial connection would be able to pass their citizenship to a child born abroad. Again, though, the substantial connection would have to be made before a child is born. So this amendment is also really important because it would protect any unattended loss of citizenship. This amendment is needed to ensure that anyone who was already a Canadian citizen when the bill comes into force will actually remain a Canadian citizen. Merci, Madame la Présidente.
Before we get into the debate, we started at 6:34, so we had the services for 2 hours, so we can end around 6:35. Would the members like to go into debate in the next meeting? Or like it's 6:34, so is it the will of the members to adjourn?
Yes.
Is it the will of the members that we adjourn the committee? Okay, thank you. The meeting is adjourned.